This episode of Art of Law, Law of Art is brought to you by Avatar Computing. Avatar Computing is an IT company that specializes in a full spectrum of services, including web development, IT support, infrastructure design, and security. Look them up at www.avatar-computing.com/commercial. Hi everybody, this is Matt Foster, and I'm here with Rich Alves again.
Hey Matt.
And this is the second episode, and as people can tell, we're doing it on the same day. But this is the second episode of Art of Law, and the law is art. And again, we got to come up with a real name.
We do.
I came up with that literally like in the car after we talked about this.
It's a good name.
So, well, it's okay, but it doesn't roll off the tongue. You know, it feels like it's having a fight with itself. Sure. So anyways, this is the second episode of whatever we're calling it. And today we figured we would deep dive a little bit more into copyrights and what it means to a designer and to an artist and to a graphic artist. And I'm afraid when I say artist, some people might think like just a fine artist, like a painter and stuff, which very important there too.
Right.
But I think that there's a lot more case study type stuff, things that we could talk about when we get into illustration and get into design and things like that.
Sure. No, absolutely. You're right. For any artist, copyright law is really paramount. It's really something that they need to be aware of, and they need to be sure that they're considering in whatever it is that they're doing, for whatever profession it might be, whether they're a professional artist or whether or not they are just a hobbyist doing it part-time. It's something where they get protection in whatever it is that they are creating. So it is important that they realize that and that they take the steps necessary to protect it.
So when we talk about protecting it, that right there in my mind as a guy creating stuff, well, am I protecting it when I go to sell it? Am I protecting it after it's sold? Like at what degree does protection, part of me as a guy who works in business and stuff also, I think to myself, well, protection is done after you sell it. Right. Is that still true when we're talking about copyright?
Yes and no. I mean, I guess it could be. There's what's known as the first sale doctrine, which basically says that after you buy something, you can use it for your own individual purposes, for whatever the conventional use of that might be. If you buy a CD, you can make a personal copy of it, and you're okay doing that. But what you can't do is you can't take that and then go ahead and mass produce it and cut into somebody else's commercial marketplace.
Which really is what I think anybody watching is what they think of when they talk about copyright issues is copying movies and again, not to get into like a weird area where everybody's going to have these really hard-edged opinions, but I mean, copying a movie is not what's illegal. Copying and selling it is what's illegal, right?
Essentially, right. I mean, what it comes down to is copyright law is really kind of a bundle of different rights that you get. So you get certain rights as a result of having copyright. And kind of going back to what we talked about in the first episode, in episode 1, you get copyright protection the moment that expression is fixed in a tangible medium, whatever the medium might be.
Okay.
But when you do have that copyright protection, your bundle of exclusive rights includes the right to display the work, the right to reproduce the work, the right to distribute copies, the right to perform it, the right to prepare derivative works, which are essentially just variations on the initial work. Okay. So those are all of the rights that you as the copyright owner have to whatever the expression might be. Now, you were saying, do you have protection after, or can you go out and copy a CD or copy a movie or whatever the case might be? If it's for personal use, the answer is generally yes. If it's for something where you go out and you try to cut into somebody else's marketplace, essentially, then it's very much a different answer, and the answer is no.
Right, and that's your Millennium Digital Act stuff, where even though you're not selling it, you're causing someone else to not buy it.
Right, essentially. Yeah. Okay. Yeah, I mean, really what it kind of boils down to is that the Congress has decided that they don't want to give somebody else the ability to cut into somebody else's turf and to take away their ability to sell their product.
Right, and it makes sense. I mean, that's not really a huge debate point to me. I mean, I understand what the logic is behind it. But so let's parse this into a way for like a graphical artist. So, and one of my questions, and I've always tried to understand where the grounds are on this. If I make a painting,
Right.
and someone, you buy it, right? And we don't really make any deal. You come in and say, "Hey, I'd like to buy that," and I just say, "Yeah, sounds great," and I sell it to you. Now I have pictures of that painting, right? And let's say I end up selling 100 more paintings and become somewhat famous, and I end up putting out a book of my paintings.
Right.
So this is where, to me, it gets murky, because you actually own that picture now. Do I retain some right where I can still make money off of a book with the picture of that picture, and not to lose anybody, but you know what I'm saying? Is so I've sold these works, I've made my money, and by right, you really have ownership of those images now. Right?
Yes and no. Yes. Yeah.
Okay.
I mean, you have.
But I mean, argue out that point for me. Is that if we were living that world, would I be in the right to make a book of my old images?
You would, and there are a couple of reasons why. I think probably what you're getting at, the most basic reason, is because you're still the copyright holder. You're still the owner of the expression, whereas the individual that purchased the painting is the owner of the tangible item, the painting itself.
Oh.
So there is a difference.
It doesn't transfer.
Right.
Oh.
Unless you agree otherwise. But, I can go into, if I had enough money, I could go into a gallery somewhere and buy a paint. I could buy one of your paintings if I had enough money, which I certainly, I'm sure those are going for way too much.
You certainly have enough money.
But I could go in, I could buy one of your paintings. I would own the painting itself. I could display it in my house. I could do whatever I wanted to do with it, but you would have the ability to prevent me from essentially kind of monopolizing that and commercializing it and making money off of it, because I'm cutting into your marketplace.
Okay, but so this goes back to my question then, I guess, and now I'm taking the other side as a proposition, which is, so I'm a collector of art. And I have the Matt Foster collection when I'm 70 years old, and it's got a Rich Alf drawing on a napkin, and it's got but it has all these things, and I want to publish that as a book. And now I know I'm taking the contrary position now, but do I have the right to do that, or do I need to approach those artists in a similar fashion? I mean, this is where copyright to me becomes really ambiguous, because it becomes 6 degrees of whoever.
It does, and it's very ambiguous. And I kind of alluded to something before, never really finished the point on it, but that's all right. But the point being that you would have rights to it in your original scenario, because there was the distinction between the tangible item and the copyright holder's intellectual property. They're intangible assets. The other kind of feature there that you alluded to, and you probably didn't quite realize that you were doing that, but you did, and it raised an interesting point, is that when it comes to a book of some sort, that's a new item. That's a new expression. Oh. So you could go ahead. It's really kind of a compilation of different paintings, I guess, is what we're talking about in a scenario like that.
Yeah.
Right. So you could get copyright protection in the way that you have put all of those paintings together into this particular end product. Now, you wouldn't have the ability to prevent somebody from, say, it was the Matt Foster gallery, and you had, I took snapshots of all of these different paintings and put it into a book. I'd have protection for my form of expression, the way that I arranged all of these in a book, but you'd still be the copyright holder for the underlying work itself. Now, unless you are planning on going out and trying to produce a compilation book as well, there wouldn't be an issue. But if you were, that's when it gets real interesting, and that's when it's a question of, okay, who actually owns the rights there in the works that make up that particular book?
Okay. So on that same premise, on that same idea, so I have a gallery, it's full of pictures. You went in and took pictures and made a book, right? But I had no plan to make a book. It's not what I'm hearing you say, and correct me, I mean, I'm just putting it out there. What I'm hearing you say would be that unless I intend to make a book, I don't really have a reason to criticize you, even though they're paintings that I made?
No.
Okay,
not really.
So I'm misunderstanding.
And I may not have been clear on it. I'm kind of just getting to the point that the That's when it gets real interesting with respect to, copyright law, and is somebody going to be likely to file suit, or can you basically get away with some kind of limited infringement, I guess.
Right.
But kind of what I was mentioning earlier, you have the ability as the copyright holder to do certain things, to display it, to perform it, to reproduce it. So that's kind of what we're talking about here. Or to also, I mentioned, prepare derivative works. What a derivative work is a kind of an offshoot of the underlying work itself. So
would this be like rap artists taking the...
That's sampling, and that's a whole different, yes, I mean, you're right, that's a derivative work, and there is a whole interesting line of case law that can go into whether or not they are kind of sampling too much, or whether or not they're actually crossing the line and infringing. And really what it comes down to is exactly that. I mean, is it something where they are taking too much of the original work, and they're taking so much of the original work that they're actually eating into somebody else's commercial marketplace?
Huh. And I mean, and I'm sure this is a topic for a later discussion, because it really does get in the weeds, but then you get into that whole situation of the original copyright holder could find that beneficial if they're becoming stale,
right,
and it reinvigorates their business. So even though it is infringing, they let it happen.
Right. Oh, sure. There are plenty of instances where you can kind of look the other way with respect to infringement, because you're actually deriving some kind of benefit from it. And it differs from what we talked about in episode 1, where we talked about trademark owners having an affirmative obligation to police their marks. That doesn't exist in copyright law. You don't have an affirmative obligation to go out there and make sure that somebody else is not infringing your copyrighted work. In fact, not only do you not have that affirmative obligation, there could plausibly be a situation where two artists come up with the same exact rendition of whatever it might be, one on the East Coast, one on the West Coast, and if they create those works independent of each other, they actually both, believe it or not, have some rights to whatever it was that they created. So it's very much a different situation than a trademark situation. I mean, the classic example is, if I happen to, on my own, come up with War and Peace, and the novel itself exists, and I've never had any access to that, well, I'm not actually infringing that copyright if it's something where I come up with that work on my own. Probably doesn't make much sense, but that's from a logical perspective, it really doesn't.
It's funny that you say it, because it actually comes into a little bit of artsiness, because they always have the topic. Well, not always. They have in art history, and Picasso's famous for this. There's the topic of affinity, and having affinity with, like in his case, with African masks and things. And the claim would be that he was copying them or stealing them or whatever, and his claim was, well, no, I had an affinity. He was influenced by them, but he simply had a motive that it was a different motive, but it came up with a very similar product.
Right.
And in all seriousness, it's not like he went to Africa. You know what I mean?
Right, right. And it really makes sense when you kind of play it out that way, and you think of what it is that copyright law really is, which is your expression of whatever it might be, your expression of a thought or an idea. So it's conceivable that two people could have pretty similar thoughts and express them the same exact way, or concepts and express them the same exact way. So that's kind of why that's the thought process, I guess, the logic behind why you would not necessarily penalize what people would refer to as an innocent infringer kind of situation.
Is that a term?
Yes.
Oh, really?
Yes. It is.
And so is it, I mean, just out of curiosity, because I don't know much of it, is that a common thing, or is it kind of an anomaly? I mean, still.
It's very much the anomaly. It doesn't happen. Yeah, it doesn't happen all that often, but it's something where conceivably it could happen.
Okay, sure. So it's not like shocking in the industry if it happens.
No, right.
So let's talk a little bit about going back to like the designer part, and the offline before we were sitting here, mentioned the example I gave you was The Simpsons.
Right.
And in that case, so you have a staff of illustrators that, and I think, if we want to get into all the technicalities, they're not freelance, they're employees, right?
Right.
And really the rule at that factory, if you will, because they're all creating the same stuff, is that anything an illustrator makes, whether it's on a phone memo or a napkin or professional artboard, is owned by the company.
Right.
And the artists have no say in any of that. And granted, they're also doing a well-known cartoon and all that other stuff. And I'm sure they're trying to keep, you know, the quality and the work within the guidelines.
Right.
But I know that scenario is very unique. But then you also have the scenarios of people that are freelancers that come in on projects.
Right.
So maybe we can talk a little bit about the differences in the approach of what a guy who maybe is more freelance, working on projects, would come to expect as his, I hate to keep saying rights, but the copyrights and the you know, what can he retain to represent himself, and how much of that is his ownership versus what's the company's. I mean, can we talk to that a little bit?
Yeah, no, sure. And you kind of really have to start with the baseline position that the creator, the author, is the owner of the rights to it. So that's something where, you know, if you are, generally speaking, if you're the person that fixes it in whatever the tangible medium might be, then you are the one that has the rights to that particular idea, that expression.
Okay.
So what it really kind of comes down to, the freelance situation I think that you're alluding to, is it's what's known as the work for hire doctrine.
Okay.
Now, what I said a couple of seconds ago about the author generally being the owner of it, or the person that fixes it in a tangible medium being the owner of it, in a work made for hire doctrine, it's kind of an exception to that. In fact, it's entirely an exception to that. It's something where if you are commissioned to produce whatever it might be, a painting, a sculpture, then the person that is doing the commission, the person that is paying you to produce that, is really, for all intents and purposes, considered the author of it. They get the copyright to that.
Yours is a vehicle to make it.
Pretty much.
Okay. And so that would be like the Simpsons thing.
Yeah, although that's a little bit different, I'm sure, because those are full-time staff members, and I'm sure that they have all sorts of provisions in their employment contracts that say that anything that they produce is the intellectual property of the corporation itself.
Well, I guess that's actually a great way to get into part of what I was thinking of, is really all of these copyright rights that an artist has are all editable based on your contract and your involvement in the situation.
That's, you know, it's a really good point. And you think about the term intellectual property. All right, well, you know, let's look at the term itself for a second. What is intellectual property? It's certainly an amorphous concept. It's not anything where it's tangible property like a piece of land or a table or whatever the case might be. But what has happened through various common law practices and statutes and just legal wranglings over the course of time immemorial is it's kind of a body of law that has developed that tries to almost ascribe real property-like rights to intellectual property. And getting to your point before, yes, I mean, really what it is that an artist or an owner of an intellectual asset has the ability, just like an owner of real property does, to sell it, to buy it if somebody else wants to buy it, to lease it, which is kind of akin to like licensing in a limited capacity, to maybe license one person or many people. So yes, I mean it really is. I mean, just that it's property as much as it possibly can be for something that is just completely intangible.
So, like, and one thing that I think of, and you know that you knew this would loop back to comic books, right? Right, at some point, just because of my fervor for comic books. But one thing that comes to mind for me is when a artist who is in comic books from the very beginning was very much a factory style. There were those very famous artists who had full control and they did everything, but that is really kind of a product of the very early stuff and the very late, like, indie work stuff. But a lot of it was kind of factory corporate, and the artist was really just a hammer, just another tool in the skill set. And but you will always know this in comic books, if a penciler, if an artist actually came up with the concept for like a hero, they always reference that that's the guy who made it, even though the company may own the hero after the fact and everything. They always do attribute even though the guy was just the guy who drew him. They didn't come with necessarily a story or anything else. They just came up with the look and this is the guy.
Right.
You always see that now that, this was the person who created that.
Right. So they kind of attribute the work to the author itself.
Well, and he's the author in that case.
Right, exactly. And it's actually kind of, and I'm sure you can appreciate this from a tech perspective as well. It's something where that's I take it, the norm within the comic book industry, because I'm not as up on the industry. Yeah. But you look at, say, Microsoft, for example. If they commission folks to make products for them, design code, whatever the case might be, I suspect that they probably are not out there saying, oh yeah, so-and-so is the source of this. It all ties back to the corporation. It all ties back to the one entity itself, as opposed to in the comic book example, where they do kind of harken back to who the person was that really kind of came up with the concept.
Right. No, it's interesting. So this idea of the creator, which is obviously going to be fascinating to any artist out there, right? Because they're all the creators. But let's talk about the licensing part. So if you're an artist, and you did some work, and let's say you were writing a book.
Right.
I'm just trying to come up with a scenario.
Okay.
And I already have the work made. You're not commissioning me to make work for your book.
Right.
You already like this work and you think it would fit well with the book.
Right.
What would make the most sense? Would it make the most sense for and again, I know this is hypothetical, so there's no right answer or wrong answer. Right. But from a legal sense, if I wanted to try and retain the work because I had some interest in it,
right,
and I wanted to stay as the owner of the work, I'm assuming I could license it to them.
Yes,
is that true?
Absolutely.
So how does that work? Like, it would just be a contractual agreement?
It is, yeah, it is. It's basically a license agreement is really nothing more than a contract at heart. It really is something where we talked about the exclusive rights that you have as the copyright owner. You could license one particular section of that, particular section of that bundle of rights to one person, and something entirely different to somebody else, or you could license them to multiple people. It depends upon what you as the artist want to accomplish.
Right.
I mean, licensing is an absolute prerequisite. You have to be sure that you are essentially protecting your rights and making sure that you are kind of controlling the situation and that somebody's not able to really take what's yours. But you can license either exclusively or non-exclusively the right to your particular picture or the right to the whatever it might be. Happens a lot in music. You could license the music to somebody that is creating a motion picture.
Right.
Now, music is a different story entirely because you have so many compulsory licensing organizations, the ASCAPs of the world, things along those lines, and that's probably enough there for an entirely different show, I'm sure.
Right.
But the point being that yes, it absolutely would make sense for the author, for the copyright holder, to engage with whoever it is that wants to use the work and make sure that they have it all documented in the form of a license agreement, and to spell out in very clear terms what rights they, as the copyright holder, are allowing somebody else to use. Because you can limit it in any number of ways. You can limit it to, you could limit it down to the number of copies. I'm licensing you to make 10 copies of this rendition, and that's it, nothing more.
Yeah. So, and I'm fascinated by this because, and not necessarily for me in particular, but in the world of the web and digital and stuff, I think that visual artists may have more of an opportunity to license, and it's kind of like the iStock photo thing.
Right.
You know what I mean? Like, and for those who don't follow that stuff, it's a huge cache of companies, but also independent photographers and stuff who basically come up with a licensing scheme, and I think iStock Photo really structures it, and they agree to it more than anything else. and basically they submit their photos
Mm-hmm.
and they meta tag them so people can find them in certain ways, and then people basically pay a royalty
Right.
to utilize those photos from then on for whatever purposes.
Right.
And it's exactly like what you're discussing is you could have 500 people using the same photo if they chose to for 500 different reasons.
Right.
But you're getting it's kind of like the old I'd rather sell one cup of water for a penny to 1,000 people than try to get $10 from one person.
Right. And essentially what you're talking about there is a non-exclusive license. I mean, I'm sure that folks don't go around talking about non-exclusive licenses, but that's really at the heart of it. That's what it is I am giving any number of people the right to use it, but none of them have the exclusive right to use it.
Oh.
But that's what it comes down to.
Yeah, no, I think that's an interesting thing. I mean, now, is copyright the same when we hit digital? Like, is it the same kind of creature, or because there's no such thing as so many copies, and there's no it's a different paradigm as far as the idea of renditions, the idea of usage, the idea of whatever protecting it. I mean,
right.
Is it totally different, or can someone approach that in the general similar terms?
You need to approach it in the general similar terms, but I will say that what you're getting at is something that law as a whole is really, really struggling with, because copyright law, case law that is trying to be applied to some of these scenarios never could have contemplated some of the cutting edge kind of situations that we're talking about today. So yes, and it is something where they're trying to address it. They're trying to get into it through the things like the Digital Millennium Copyright Act. But it is, at its heart, it still is the same basic premise that that they're trying to fit today's type of scenarios in with case law that dated back to the Oscar Wilde paintings, or I mean, it really is it's a difficult situation for copyright law as a whole. It's tough to fit it into the modern day kind of situation.
I mean, as a person who does art, but also creates things, but also works in the business end, I don't know how they can reconcile it. I really don't, because the internet, as much as the world wants to control it, it's the Wild West. I mean, they're trying to control the pipes more, and I personally, as a geek, I don't like that. But as an artist, I understand what they're trying to do.
Right.
But at the same time, there's something about the web that's nice to be free too.
Yeah. So. No, absolutely, and you're entirely right that there are the potential for copyright infringement has really just exploded. Good example, and nobody even uses this technology anymore, but a good example is when there used to be a lot of frames of different websites, and you could take a look at this one or that one. Yeah. Well, and what it kind of really did is it pulled into the modern kind of internet environment the whole issue of, geez, if I take these individual pieces and put them into we talked about a compilation a little while back, a derivative work. Do I have the ability now to pull these other works into my site and claim that this is my site and it's my expression and I arrange them this way? Or do the other sites have the right to say, no, you can't do that? I mean, generally the answer turned out to be, no, you can't pull it in, because they're kind of cutting into, again, it goes back to cutting into somebody else's potential commercial marketplace. But it's it kind of gets to that whole notion of how do you reconcile copyright law, which dates back to, frankly, British common law, and try to put it into today's environment with the internet and taking creating a link to somebody else's page. It's just it's a difficult situation.
Yeah. Well, I mean, the other thing that I would think would be problematic for an attorney is that you live in a world where you have what's the guy's name, Cy, the guy who the Gundam stuff, and he's a guy who willingly waived his copyrights and said, I'm not interested in holding the copyright because I want it to be as pervasive as possible, and now he's ridiculously rich, based on marketing it after the fact, and that I can only assume that just complicates the issue, because now you're going to have motivated people to try and take on, and not that he's the first, but he's a shining example of how it could work.
Right. And you say it could be frustrating from an attorney's perspective, and maybe yes, but at the same time, it's something where it really opens up a broader way of approaching intellectual property.
Okay.
And what it kind of allows you to do is to think about it more strategically, not just simply as a rights issue, not simply as hey, I'm going to be able to prevent anybody from ever using this work. It allows you to think of it more from a business perspective, and to view it more of of an asset to whatever it might be, whether it's Cy and his individual endeavor, or whether it's you go to a Microsoft corporation where sometime back they made a concerted decision to kind of abandon a lot of their their very rigid enforcement of some of their rights, and try to get into some of the open architecture, open software kind of situations where they collaborated more with a company like a Red Hat or a Linux or whatever it might be. So it does, though. It allows you to treat it much more as a strategic asset, as opposed to simply saying, I'm the owner of this and I'm not going to let anybody else touch it. So if you have clients that are willing to engage with that, it kind of creates a whole different avenue for attorneys, and gives them a way to present to their clients an entirely different way of looking at the situation.
Yeah, well, I mean, I would assume that's where, as an attorney, you get to flex the creative muscle also a little bit, where it's you get to view it from a different angle, and it's not just about it's still about the law, but like you're saying, it's not as closed door.
Right. No, yeah, it is. It goes more from what once was considered a rights issue to now more of a strategic business asset, and really what companies need to do. And I know it's getting kind of far afield from the artists that we were originally talking about, but it forces companies and even artists individually to think about things in a more strategic way. And what is it that's going to really further their end objective?
Yeah, well, defense to offense.
Exactly.
Is kind of how I'm picturing what you're saying. Is that the walled garden approach, which I think is really the best, example is like the Apple thing,
right?
Where they're very, very closed door about everything, and they has extreme tight control before it gets unleashed on the world, versus the Cy approach, which is very much a put it out there and let's it's more of an aggressive offensive attack,
right,
instead of a defensive rollout type thing.
Right. No, absolutely. Yeah.
And I personally think an artist, a visual artist, but also a performance artist, would actually, in the world where you can be viral, would benefit from being more offensive.
It is. I mean, the whole social media world, the whole being able to go viral, it really, really has changed the game. It really has, and it's something where anybody that's getting involved with it now has to really consider that. Otherwise, they're doing themselves a disservice.
Yeah, thinking old school.
Exactly.
This is a fascinating topic. I keep coming up with new interesting things that are sparking off on this. But what am I not thinking of? Is there some aspect of we talked about an artist being able to protect themselves, to what degree makes sense. We also talked about the flip side of being, open with it if it's strategically in their advantage. We've talked a little bit about how they can license work.
Right.
What about if there's an infringement? And this is something that I've never had to pursue, so I wouldn't know what step one was. But if someone did blatantly, infringed on a copyright in a way that hurt me,
right?
Is it just a lawsuit? Is that what we're looking at?
That's what it is.
Or is there a certain way to file that? Or?
No, that's what it is. Yeah, it's if you're a copyright holder and somebody infringes your rights, it's a lawsuit. And what the Copyright Act provides for, and this is something where it gets expensive. Obviously, most attorneys don't come cheap, and it's something where if you're going to prosecute a lawsuit in federal court, it's going to be a drawn-out endeavor. It's not going to settle in a matter of a week or 2 weeks. But the pot of gold at the end of the rainbow is that in certain cases, you're allowed for certain statutory damages, and then on top of that, attorney's fees potentially. Okay. So, yes, as a copyright holder. If it is something where somebody's infringing your work, it does come down to litigation. But you should not just simply say, well, litigation's too expensive, there's no possible way I can pursue it. because there might be the potential that you might not have to pay anything. You're going to be entitled to attorney's fees as a matter of the settlement.
Is it not smart? And I'm saying this because I would do it, so I assume it's not smart, right? But if I said, well, you know what, instead of litigating, instead of going right into that, I'm going to have my attorney write them a letter,
Right.
and try to work out, maybe they'll sit there and say, we didn't think of it in those terms, and now that you say that, you have a very good case. I mean, is that a smart first step, or does it depend on the situation?
No, that's really always a smart first step. I mean, you never know what's going to happen in litigation, so I would never advocate that somebody as a first step file suit as opposed to engage with the potential infringer and try to work it out.
Yeah.
You never know. I mean, you really don't. And you might have the greatest, most rock-solid case that has ever existed, but yet the jury hears something differently, and you get nothing.
Yeah.
So
if you're litigating against Disney, you'll lose.
pretty much. You got the deep pockets, no doubt about that.
Yeah.
But yes, I would say that it's actually always a good idea to try to settle out of court with anything. You just don't want to, one, take on the risk, or two, take on the time and the expense and the energy that goes into it if you can come to some kind of sure thing agreement outside of court.
Right. Okay.
However, having said that, I would not, if it doesn't work out that way, don't just necessarily say it's going to be too expensive, it's going to take too long, I'm going to throw my hands up and just kind of hope that it doesn't get worse kind of situation. Right. There is the possibility that an artist or anybody could be entitled to attorney's fees and could be entitled to statutory damages. So it is something where it needs to be considered.
Okay, no, that's a good point. I mean, the mind frame that I'm coming from with that is, a lot of artists that I personally would think they don't have deep pockets. Mm-hmm. It's not usually their biggest thing, and they're also not usually represented on a normal basis.
Right.
I mean, it's not like they're hanging out in courts in general.
Right,
so.
right. And I don't know how much of our audience knows or does not know of some of these organizations, but there are attorneys out there, volunteer lawyers for the arts, for example, that would potentially...
Is that the name of an organization?
It is. Yep. That would take on some of these cases and potentially represent folks on a, either a dirt cheap or potentially even pro bono type basis.
No kidding. Mm-hmm. And is that a mass thing or a federal thing?
It's kind of both. There is a Massachusetts chapter of it, but they're kind of nationwide in scope.
No kidding. We'll have to put that in the show notes for people.
Absolutely.
We'll put that on the page. That's interesting. Are there only because you mentioned it, are there other groups?
There are, and some of the names are escaping me right now, but there are groups that are out there that are in it for kind of the greater good, that want to represent artists and want to further the whole community and help them, because they realize exactly the situation that you're talking about. It might not always be something where the artist has enough in the way of resources to go up against a Disney, right, or to go up against a whoever it might be. So they're out there, and generally speaking, they're a good resource to have, at least a good first stop.
So Disney, let's do this thing.
Okay.
No, but I mean, one of the is a copyright or is a patent? I'm assuming it's copyright based on what we're defining copyright as.
Right.
But isn't the story? And I love Disney, so I'm not knocking them, but at the same time, every big company has their little thing, right?
Right.
And what is the deal with? They had a copyright, and copyrights last.
Generally speaking, lifetime of the author plus 75 years after the author passes away.
And they're one of the few companies that got an exception on that?
Well, I guess it depends upon which situation you're talking about.
Yeah, well, I mean, I guess some of the thing I'm thinking of is, and again, I don't know all the details of it, but the story you always hear is that a character, let's say Snow White.
Right.
I'm trying to think of a character that I know is old.
Right.
But a Snow White, which was a fairy tale character already,
right.
It was public domain.
Yeah, exactly.
And they copyrighted it.
Mm-hmm.
So I mean,
yeah, and that's kind of the situation I thought you were referring to. And really, we talked before about how you get protection on your expression of a particular concept. So they have kind of come in and they have taken what was in the public domain and almost put their own spin on it and, or in fact, not only almost put their own spin on it, entirely put their own spin on it. And a lot of their stories are, like you alluded to, they're stories that date back to fairy tales. Go back to
Germany.
Yeah, exactly. But it's their expression of that now that is something that they have protection in. They can't prevent somebody from using the German fairy tale, but it is so closely tied to it. Their expression of it has kind of morphed into its own being, and that's what it is that they have protection in.
But that part I can at least grasp, which is look, we've made a exceedingly popular rendition,
right?
And we want to protect that as an asset. Doesn't mean that someone can't go make Snow White on their own, but it can't look like our Snow White. I get that as an idea. Right. What about the 75-year thing, though?
Yeah, well, I mean, and that's all a matter of statute at this point, and that's all a matter of, frankly, Disney being able to lobby for it. I mean, it's changed many times over the past century. In fact, actually, the copyright law that we're working with right now didn't even exist until 1978.
Oh, really?
So up until that point, it was an entirely different scheme that we were operating under, or at least it was a very different scheme that we were operating under. And yes, Disney is one of the I'm sure, major players, or at least somebody that had a very strong vested interest in it, has lobbied and has kind of worked with their representatives to strike copyright laws that are kind of in their favor in a lot of ways.
Not in the Disney interest.
Yeah, right. Exactly. So, yes, because unfortunately it's something where it's a matter of law. The lawmakers are subject to, I don't want to say influence, that kind of, skews it, or at least puts a bad connotation on it. But, I mean, any constituent can lobby their representatives and try to come up with something that is more advantageous to them. So, yes, I mean, it is something where a lot of the rights that Disney might now have may not have kind of still been in existence had Congress not taken action.
Right.
But they did, and
it's a fascinating thing. That to me. I mean, I know it's kind of in the art realm, but I mean it's pop culture realm. Definitely.
It is.
And so let me ask you this then, based on that, because I'm interested in this fact that they even changed in the 70s. Mm-hmm. So is the trend to elongate these things, or is the trend to shorten them?
The trend is very much to elongate them.
But is that only because the only lobbying parties are the ones making money off these copyrights? Or I mean, and I don't mean that in a mean way. I just mean that in so the only people addressing it are people that wish to elongate it.
Yeah, well, I think that's kind of what it comes down to, is the fact that, frankly, the people with the greater sphere of influence are the people that have the deeper pockets and can do that benefit by having an elongated duration on copyright. Now, it is something where, if you go way back to the Constitution and you take a look at what the copyright law itself is, or the copyright clause, patent and copyright clause is, it simply says that Congress has the right to protect or to give exclusive rights to authors and inventors for limited periods of time. It doesn't define what limited periods of time might be.
Oh, okay.
It's gotten to the point now where limited period of time is the lifetime of an individual, and then 75 years after they pass away. So it has gone very much to, I think, in a lot of ways, stretched the definition of limited. Huh. I mean, who would think that limited is my entire lifetime and then 75 years thereafter?
Yeah. Well, now, and I know you probably haven't seen this, but Dennis and I do the other show, the Modern Art Family Tree, and we do a little bit of quasi research on the people, but we're really taking it from an artist standpoint.
Right.
But when we were doing Millet or Millet, and I'm sure people will correct me either which way, but what we found interesting is, as we read up on him, is that when he died, he was destitute.
Right.
And apparently, in France at least, the laws around, because he left a wife and kids without any money, and he had works that had been sold, but they got no money for that. The families didn't get money for that. They actually changed the laws based on his horrible situation.
Really?
Yeah,
interesting.
He was one of the. Yeah, you might find it interesting.
I do.
Because he was one of the igniting factors of how they suddenly had to compensate the families of artists even after they died
Really?
when work was resold from like a gallery situation or something
Yeah,
like that.
interesting.
Instead of it just becoming the sole property of
right.
yeah, and which kind of it only rings a bell for me when you say that 75 years after they're dead.
Right.
It would assume, I'm assuming that means that their inherit, their
heirs,
children,
right.
yeah,
Yep.
Would
Still
retain
have
that
exactly,
copyright.
right, exactly.
So yeah, just a fun fact,
Yep,
if you
yep.
will.
No, that's
you might
interesting.
find interesting.
Yeah, I did not realize that. It is interesting, and you referred to the heirs of an artist, or in this case, Millet, or
Yeah.
however the proper pronunciation might be.
I don't know. Yeah.
But kind of what that ties back to again is trying to ascribe actual property rights, something that you can pass down to your heirs, to something that's inherently intangible.
So maybe launching from that, and I don't know if this is if it's totally different, just tell me. But does that go to like estates and stuff?
Yes, absolutely.
Okay,
it definitely does.
So like the one that I'm thinking of is like Andy Warhol, right? Andy Warhol had a huge collection of work, and he did all these magazines, and he did all this stuff.
Yeah.
And of course, there was this huge thing with what to do with his estate when it was done. But I mean, how does that relate to the conversation?
No, I mean it's critical to it in a lot of ways for something like an Andy Warhol, but even for individual artists.
Yeah.
What it kind of ties into is estate planning, and it really comes down to what is it that you're going to do with that property. I mean that copyright can certainly pass down to anybody that you want it to, as a matter of estate administration, as a matter of probate law. So you could pass the copyright to your sons, or you could instead, if you decide you wanted to give it to me, you could give it to me. I mean, it's whatever you want to do with it. But yes, I mean, really, it becomes a piece of property. It becomes an asset like any other asset, and you have to make sure that you are doing proper estate planning if you have specific desires for that. If you want it to be handled a particular way, you have to be sure that that's included in your estate plan. Otherwise, it's distributed per the state laws, what's known as the laws of intestacy, and it very well might not be what you want as the individual.
That is such a topic that I don't think any artist, unless they're suddenly found out they had cancer, is approaching at all. Like when I think of cataloging my work, protecting my work, what my family receives or what happens if I died with the work, really doesn't come into fact. It's just a very interesting point that I think is very relevant for our audience, especially. Is it's not something I would have thought of unless you said it.
Right. No, I mean, a lot of people are probably not as vigilant as they should be about doing estate planning to begin with.
Sure.
I'm sure that especially when you're talking about something that a lot of people don't have a real firm grasp on. I mean, sure. Anybody knows that, all right, if I pass away, I want my car to go to whomever, or I want my house to go to whomever.
Right.
But they don't really think about the intellectual assets, the intangible assets, and that's something where it needs to be considered in your greater estate planning work.
That is great. All right, I think we're pretty much up to time. So
okay.
So thank you, Rich Alves, for being here.
Thank you, Matt. I appreciate it.
Yeah, and we will be doing more. But this was episode 2. 2 down.
2 down, and many to go.
That's right. So thank you very much.
Thank you.
Until next time. This was whatever we're gonna name it. Right?
Are we gonna have a title by next time?
We will have a title by next show. Promise. So, all right. Thanks again.
Thanks.